So hello, everyone. I was thinking about where to start this presentation. There's so much to talk about. And so I'm going to start with my suit, which may seem like an apropos way to begin. But every spring, I go and buy a new suit that I wear for the entire season to all the presentations that I give. So I went to the usual store that I like, and I couldn't find anything I wanted. Well, then I came upon this lovely pink suit, and I thought to myself, should I? Should I? Yes. So I brought it home, and my husband said, I have never seen a woman in a professional environment wear a pink suit. I said, look at me now. And he said, well, do you want me to return it? I said, no. And I said, pink is the color of joy and the color of celebration. And I said, I'm going to wear this suit all this summer when I'm celebrating the South Dakota versus Wayfair decision. And the place that I envisioned myself wearing this pink suit was in this exact presentation. So I'm very pleased to be here with it. And in my evaluation, you can give me a thumbs up or a thumbs down for the color. So I'm going to start with some overall observations about the term. Then I'm going to talk about a couple cases important to states. Then I'm going to offer a tribute to Justice Kennedy and talk about Judge Kavanaugh, i.e. look into my crystal ball. So this was a significant term for state and local governments, as many have been in recent years. There was a big labor case, immigration case, and a number of law enforcement cases. But the court left many questions unanswered. For those of you who are busy reading the news at the end of June, the gerrymandering case turned out to be a dud, as did the Kate case and another First Amendment retaliatory arrest case. So for one justice, this was his first full term. That's, of course, Justice Gorsuch. For one justice, this is his last, Justice Kennedy. The court decided about the average number of cases, 72. What was different about this term, though, is that typically the court issues about 20% of 5-4 decisions. In this term, we were at about 30%, which is quite a bit higher. It's not unusual for the court to have 50% of its cases be unanimous. This term, 39%. So a lot less agreement on the court. But what makes this term particularly remarkable is this. In all of those 5-4 cases, every single one of them, Justice Kennedy sided with the conservatives. Long gone are the days of just 3 years ago when the Supreme Court allegedly had the most liberal term since the Warren Court because of a health care decision and the same-sex marriage case. The next term, we have 37 cases set for oral argument, which is about typical. Justice Thomas, as usual, wrote about 31 opinions. I try to avoid reading any of them. I'm never successful. Anyone who goes to oral argument, Justice Sotomayor can't stop talking, much to the annoyance of Justice Roberts, who frequently cuts her off, especially when she asks a question at the buzzer. Justice Sotomayor and Ginsburg wrote the most together, or joint opinions the most together. Sotomayor and Alito were the most apart. I'm surprised that's not Thomas and Sotomayor. And interestingly, in the majority of the most this term was not Justice Kennedy, it was Justice Roberts. And that may be a sign of things to come. So for now, as we look into the future, we will have soon, very likely, Chief Justice Roberts as not just the chief, but also the swing justice. So the question really for all of us is, how much will he be swinging exactly? In the last term, he only voted 3 times with the liberal justices. One of them was in the Wayfair decision, the other one was in Carpenter, which was the cell site location data case, and the other one was in a very obscure statutory case. It'll be curious to see how Justice Roberts' tenure changes as he ends up on the court. So here it is, South Dakota versus Wayfair, what everyone wants to talk about, or at least I want to talk about. So I'm sure most of you are at least familiar with the ruling in general. The Supreme Court held in a 5-4 decision that states and local governments may now require vendors to collect sales and use tax even if they don't have a physical presence in the state. The court said it was enough that Wayfair, the company bringing a lawsuit in this case, had a substantial nexus with South Dakota by doing a fair amount of business in the state. The court said that there were between $8 and $33 billion on the table in this case, and the decision was actually a 5-4 case, which was quite remarkable. I was really hoping it would be more like a 9-0 decision, but beggars can't be choosers, right? And 5-4 is as good as 9-0 at the end of the day. So the precedent, many of you are familiar with, since the 60s, the court had basically said, unless you have a physical presence in this state, you don't have to collect sales or use tax. The court had affirmed this opinion in 1992, right before Al Gore said he invented the internet. And so the court, didn't see at the time what was going to happen with all the changes in terms of e-commerce. So the long and the short of what happened in this case is that the State and Local Legal Center had filed an amicus brief in a case that challenged a law out of Colorado involving the state collecting sales and use, or setting notices to get people to collect and pay sales and use tax on their own. But the question before the court in 2014 wasn't whether to overturn Quill, it was whether or not this challenge should be heard in federal or state court. But the SLC had filed an amicus brief. And that amicus brief encouraged the court to overturn Quill. Well, the court didn't do that, unsurprisingly, because that wasn't the question in the case. But Justice Kennedy had written an opinion saying, I was on the court in 1992. I see the world has changed. Maybe we should overturn the Quill decision. So South Dakota passed a law saying if you're in our state and you have no physical presence, no problem. You're going to collect anyway, as long as you do $100,000 worth of business or 200 transactions. It was very clear that this law violated the Constitution. That was its entire purpose. The purpose of it really was to get to the Supreme Court. So the court heard the case, and oral argument was held in April. And it was interesting. Before going into oral argument, we knew we had 3 votes for overturning Quill. Justice Kennedy, obviously. Justice Gorsuch, who when he was on the 10th Circuit had written an opinion saying he was skeptical about the way Quill was decided. And then Justice Thomas said, in 2003, he said, just like Santa Claus, I no longer believe in the Dormant Commerce Clause. That was in 2003. So in 1992, he had joined the majority opinion to keep Quill as the law of the land, but he changed his mind. So oral argument was very interesting. I think I've attended about 100 oral arguments in my lifetime, and I believe, but maybe this is an exaggeration, that it was the most animated I'd ever seen Justice Ginsburg. Justice Ginsburg's not a big talker at oral argument. That's just not her way, but she couldn't stop asking questions and made it abundantly clear that she was on our side. But the problem was there was no clear 5th vote. It looked like we could lose this case again. And so it was a 10th time between oral argument and the actual decision. So why did the court decide to get rid of Quill? Well, I have all the legal reasons that the court cited in their opinion, but I'm going to tell you something much more interesting than the legal reasons. So Wayfair's website, before South Dakota's brief, had said on it, basically, shop at Wayfair. You don't have to collect sales, or you don't have to pay sales tax. I'm not kidding. In South Dakota's brief, they pointed this out, and I really believe that's why the court decided to overturn the Quill decision, but the legal reasons are actually all listed on this screen. Now, it's a really big deal for the Supreme Court to ignore precedent. The term stare decisis means as it stands. You're going to be hearing a lot of that phrase in the next couple of months as we deal with Judge Kavanaugh. And I have not really verified whether this is true or not because I so desperately want it to be true, and it might not be true. I do believe that the last time the Supreme Court overturned precedent was in Citizens United, which not only was a long time ago, but was a case that was a really big deal. So the court studied all the statistics that are all the things that you took with you when you went on your Hill lobbying days and you asked Congress to do something about this case. Those are all the factors that the court looked at. And the court directly addressed the issue of why not wait for Congress. And this is something that Justice Ginsburg talked at length about at oral argument. It was the idea that, look, Congress didn't make this rule. The Supreme Court made this rule. And so it was up to the Supreme Court to change it and to turn it around. The other thing that's sort of interesting, any of you who follow the careers of your attorneys general know that they tend to file Supreme Court amicus briefs on blue and on red sides without really any exceptions. It's not, in fact, unusual to see 2 state briefs, one from a red perspective and one from a blue perspective before the Supreme Court. Here we had 41 states. Mind you, 6 states don't have sales tax, who all filed an amicus brief and said, we want Quill overturned. And the court did notice that in their opinion, perhaps unsurprisingly. So here's how the votes came down. The leader of the dissent was Justice Roberts, and so it was Justice Alito who provided the 5th vote. So you might wonder, well, why was it Justice Alito who provided that vote? Well, a couple of days later, Justice Alito was going to write the Janus decision involving union dues. I knew that. Everyone knew that he was going to do that. And I think he worried about looking like a hypocrite, being unwilling to overturn precedent in one case, but willing to overturn it in another case. The other thing that I find sort of interesting and ironic is that you and I know, right, that this case is not about raising taxes. But everyone in the world thinks this case is about raising taxes. And it is sort of interesting that it was the conservatives that got together and said, let's raise taxes together. But again, remember, it's not about raising taxes. So what did the Supreme Court say about South Dakota's law? The court said, well, to force a retailer with no physical presence to collect, there still has to be some substantial nexus between that retailer and the state. And the court said, we see a substantial nexus in this case with Wayfair because, $100,000 worth of transactions is a lot of business, and Wayfair has a big internet presence in the state. The court also looked at 3 features of South Dakota's law and said, these are the features that we think make a good law, a law that likely isn't unconstitutional in any sense. The court didn't rule specifically whether all these factors would deem a law perfectly constitutional, but said these are the factors that a law should have. First, providing a safe haven for small businesses, which of course South Dakota's law does. South Dakota is not collecting retroactively. And then finally, South Dakota is part of the Streamlined Sales and Use Tax Agreement. So the dissent in this case, interestingly, was very short. If you consider the fact that it's rare for the Supreme Court to overturn precedent, none of the justices in the dissent seem all that concerned about it. In fact, they all said, Bellis House was decided wrongly anyway, but kind of complained about the fact that they were worried about small businesses. And this is a very Justice Roberts sort of term. He called the majority opinion breezy in its dismissing the idea that it would be hard for small businesses to collect. Basically, Justice Kennedy was like, someone, not me, will come up with some software to solve this problem. So, but Roberts wasn't quite as convinced. So now, going forward, there's a number of things for your states to think about as you figure out what do we do as a result of this ruling. And I'm going to talk about all those things very briefly going forward. So first, about half of your states are on the Streamlined Sales and Use Tax Agreement. If you'd never heard of this agreement before, that probably would make you and your average American in the same boat. Basically, this agreement simplifies tax collection, and that's why Justice Kennedy liked it so much. So here's a map that no one can read that shows all the states that are in and all the states that are out. I know I have to use more graphics, but sometimes they're sort of hard to use. So a lot of states have notice and reporting requirements like Colorado. I think those are going to largely fall by the wayside. But not all states have an economic nexus like South Dakota does. So I think probably next time legislatures are in session, January of next year, those states that haven't come up with an economic nexus are likely to do so. So these are the states that do and don't have an economic nexus. So one of the problems many of you know also with this is that when you look at Amazon, so they collect for their own sales, but they don't collect for their marketplace sales. These are the sales of small vendors. Some of you have passed laws that said if you're a big Amazon, you're a big eBay, you're going to collect for your small sellers. Not a lot of states have passed these kind of laws, but that's going to happen more in the future as well. Then the big question is, when are you going to start enforcing sales tax collection? There's a variety of dates on the screen, and states are going to choose that as they go forward. So most states that have done legislation on this have followed thresholds similar to South Dakota's. And Hawaii, unfortunately, is trying to collect their sales tax retroactively, which is not a great idea. But, we love Hawaii for every other reason, right? So that's South Dakota versus Wayfair, a really important, significant decision. And I'll end by saying that, one of the takeaways I think that's worth thinking about in terms of that case is, if you think about the last 12 years, 10 years, whatever time frame you want to look at that's been relatively recent, I think you could make a good argument that the second most powerful person in this country has been Justice Kennedy. By occupying this swing vote on the Supreme Court, he was able to lay out gun rights, Citizens United, same-sex marriage, roll back the death penalty. I mean, there is little that Justice Kennedy did not accomplish in the last 10 years that he wanted to. And I think one of the things that makes what he did maybe a little unique is that, if you're really powerful, you don't have to correct your mistakes. You don't have to admit you're wrong. You don't have to change things. And I think that what Justice Kennedy did was very powerful in terms of his own personal power of saying, hey, I admit I got it wrong, and I want to turn things around. And I give him a lot of credit for that. And I'll talk more about that later. So Janus is a huge case, but it was very much overshadowed by the travel ban and Justice Kennedy's retirement. This decision came down and Justice Kennedy announced his retirement a couple of hours later. And so the case didn't get the attention I feel it deserves. So here's the deal on this case. It only impacts about half of the states in this country. So a number of states, about half, had state statutes that said that union and management could agree to something called agency fee. And agency fee or fair share is the notion that if a person doesn't want to join the union, that's fine, they don't have to join, but they have to pay almost all the union dues. They don't have to pay the union dues that go towards political costs, but they have to pay the rest of the union dues. This is called agency fee or fair share. The Supreme Court for a long time had been looking like it was going to overturn fair share, and it did, and this was a 5-4 decision. So this chart shows the former right-to-work states, and now we have all right-to-work states essentially, and you'll see that agency fee was common in the Southwest, in the West, the Northeast, and in the Midwest, but less so over time. So here's the deal. There's a case from the 70s called Abood, and this is where the court said it doesn't violate the First Amendment to basically force people to pay union dues even if they don't want to. And what the Supreme Court did in the Janus decision is it overturned Abood. And the court had been criticizing the Abood decision really before 2014. And the court was poised to overturn Abood in 2006. After oral argument, Justice Kennedy died, and the court was 4-4. So this is kind of an interesting case because when oral argument happened, we knew that only Justice Gorsuch's vote was going to matter. Now, if Justice Gorsuch was a moderate conservative, that would have been enough for him to vote to overturn Abood, right? But he's not a moderate conservative. He's a conservative conservative. But he did the same thing at oral argument that you would have done. He didn't ask one question. So we didn't really know what he was going to do, but we knew what he was going to do. So the court said, the main justifications for agency fee, they don't make a lot of sense. Like, for example, keeping labor peace. Labor peace exists even if there isn't agency fee. Look at the federal government where there's a lot of labor peace and there's no agency fee. I also wanted to point to them, like, look at West Virginia and Oklahoma, but no one asked my opinion. So, and the other thing is this concept of free rider. The court had long said in Abood, like, if you're going to get the benefits of the union, you should be forced to join the union, or at least pay the dues if you're not going to actually join. And the court had this great line about how the guy in this case, Mr. Janus, didn't see himself at all as a free rider. He saw himself as being sort of forced to go along with something that he didn't agree with at all. So again, the court had to wrestle with stare decisis. Were they going to overturn precedent or not? And the court admitted, look, unions have relied on this ruling for a long time, as it has, quite frankly, management. But the court said, reliance, it's not going to carry the day. So this is sort of the bottom line on this case. Public sector unions can and do exist without fair share. But this case is really important for unions in terms of funding because remember, everyone who's basically eligible to be a union member had to pay. Now, none of those people have to pay anymore. This case was called the Citizens United of Collective Bargaining, and fair share is absolutely a cornerstone of bargaining. The other thing, too, is no matter how you feel about fair share, this is certainly a loss for state sovereignty. I mean, all these arrangements were allowed because states agreed to allow them. States agreed to let management and unions have these arrangements. And that was kind of what Justice Kagan pointed out in her dissent, famously saying that the majority was using the First Amendment as a sword. And so there are some state sovereignty implications. It's very likely that union membership will take a hit in your state. It's interesting to see what happened in Wisconsin, but it's important to note in Wisconsin that not only did fair share go away, but the unions can only bargain now over wages. So you may in Wisconsin have a reason not to join the union simply because the union can't do that much for you, but I have some statistics on the screen where you can see how much union membership has declined in Wisconsin as a result of them sort of getting rid of their labor laws. There's also been some other sort of interesting fallout. There's a whole bunch of litigation over whether union members should be able to, or people that joined the union that didn't really want to, or paid the union dues rather, over the last 3 years, should get that money back. There's lawsuits all over the country on this. And my thoughts on this are that's crazy. I mean, the Supreme Court rule should just be one going forward. But the lawsuits exist, and they're in a number of different states, and only time will tell how these play out. A number of states have also taken some action to try to protect unions. For example, expanding the class of people that can join unions. So the question really is this. I mean, there's a huge right-to-work movement in the United States. There's a huge movement to get rid of unionization generally. So the question really is, what is the next move? From a public sector perspective, my guess is the next move is trying to challenge the constitutionality of unions as an exclusive bargaining representative. The concept there is the idea that if there can only be one sort of union representing a class of people, because if there's multiple unions, like how is the management supposed to deal with all these unions? But the people that don't want unionization say, well, what if I don't want to join that union? Like, what if I want to join my own union different than that union. The court has recently denied a petition on this issue, but presumably they wanted to deal with the Janus issue first, and if they want to get to this issue second, that would have been the more logical flow of how the cases should go. So all this to say that by no means are we done with cases involving labor law, but this one is a very sort of big one. So the travel ban, another very, very big case. So in this case, the Supreme Court, or I should start with what the travel ban most recently said. The most recent travel ban, the third version, barred people to immigrate from countries. It's now actually 5 countries. Apparently, Chad was on the list because they didn't have passport paper. I'm sure many people who are against the travel ban would have done a GoFundMe campaign to get them passport paper, but they were put on the list anyway, but eventually they were removed from the list, presumably because they got the passport paper they didn't have. But there are 5 countries where immigration has been suspended indefinitely into the United States. And the travel ban was held lawful and constitutional, again by a 5-firm led by, Reed Roberts wrote this opinion, but Kennedy's vote would have been important. So there's 2 really important facts to understand this travel ban. The first one is this: we are talking about the 3rd travel ban and not the 1st or the 2nd travel ban. What is different about the 3rd travel ban is this. Before, President Trump had just said, I'm banning a bunch of people from these countries. In the 3rd travel ban, there was a worldwide search of whether countries complied with the standards that the Trump administration wanted for admitting people to the United States. About 30 countries came up wanting. So the Trump administration went back and said, can you fix things in your state or in your country? A bunch of states came back and said, yep, we've got it taken care of. But then a bunch of countries couldn't. And those are the ones that ended up on the list. But those were also countries that before had been targets of the travel ban. So this travel ban was a little different than sort of President Trump pulling a list of countries out of a hat and saying, I'm going to ban people from these countries. And then the other really important fact about this case was that President Trump had made a number of anti-Muslim statements throughout his campaign, and significantly, at least in my own mind, was the fact that after the third travel ban was on the books, he had tweeted out those videos, the kind of over-the-top videos from Britain about, guys in beards like smashing, like statues of Jesus, and one of his communications people said, yeah, and that's why we had the travel ban. So there have been all these kind of statements, including statements contemporaneous to the president actually having the travel ban. So the Immigration and Nationality Act says that the president can suspend entry into this country whenever he finds that entry would be detrimental to the interests of the United States. According to the court, this language, and I love this word, this is why it has to be Roberts, exudes deference to the president. And so he found that the travel ban to be well within the statute. So many of you who filed this case, you probably heard the argument, well, what about this language in the statute that talks about no discrimination in the issuance of visas? The court said, yeah, there's language on that, and that's true that there shouldn't be discrimination on the basis of countries in terms of visas. But visas apply to people who are already from countries that are able to be admitted to the United States. So there's sort of like there's a 2-step process. One, are you just eligible to come to the United States? And if you're not from the right country, apparently you're not eligible. Then if you are eligible, can you get a visa? So the court said that language applies once sort of more general eligibility has been determined. And the court, of course, pointed out that Reagan and Carter, too, had banned large swaths of people from particular countries. More controversial, though, was the court's ruling on the Establishment Clause. The court noted, look, this proclamation is neutral in its face. The court also said, what the court ultimately said was, we're just going to apply rational review. So we're going to take a look at the travel ban in terms of religious discrimination, but we're not going to take a very close look. And the court said, there's obviously other reasons other than discriminating against Muslims to have a travel ban. And the court said our rules are only going to apply, what we said in this case is only going to apply to a national security directive applying to the regulation of aliens abroad. So there were 2 dissents in this case. The Justice Breyer dissent and the Justice Sotomayor dissent. I call the Justice Breyer dissent the sort of like thinker dissent, and the Justice Sotomayor dissent from like Myers-Briggs. So Justice Breyer was more like, I'm not really sure whether the travel ban is unconstitutional or not, but I'm skeptical enough about it that I'm pretty sure it is. But more of his point was that there were exceptions to the travel ban, like for people that could get in the country from Yemen for medical reasons. And he said, I don't really see any evidence that these exceptions are actually being applied. So I'm concerned that this travel ban is kind of just a sham as it is. And Justice Sotomayor was like, give me a break. The travel ban is a sham. I mean, look at all these statements. And she was not, it was a more of an emotional appeal. So I'll just give you a few reactions to this case. First of all, the mainstream media, very much in my opinion, overstated the court's, the insignificance that the court placed on the statements of President Trump. Like, if you would have looked at headlines the day after the trial ban, it was, President Trump can say whatever he wants, the Supreme Court doesn't care. That is an overstatement. The court was very clear, like, we're applying these more relaxed rules because this is a national security directive regulating the entry of aliens abroad. And so the court just said, in this narrow context, we're not going to look at closely as religion as we normally would. Of course, this gives little comfort to people who are otherwise challenging other things that President Trump has done that they feel are immigration related and possibly related to race and national origin. This case was dubbed a win for Jeff Sessions, absolutely and unequivocally. Nothing could be more true than that. It was his department that doggedly went to all those countries and said, will you comply with our procedures? And most of them said yes, and a few said no. So I think that is the person who really won in this case. And the last thought I'd say is this. Justice Kennedy is perhaps most known for having sort of a sense of pulse to our country, of knowing like what Americans are willing to tolerate and what Americans don't really like at all. And the same is a great example of that. He was right in realizing that most Americans, like or dislike, would tolerate same-sex marriage. I mean, we have I think, somewhat of a cultural consensus on this point, even if it's not like and dislike. And in this case, I'm just not really sure. I'm not really sure where that all came down. But at the end of the day, the trial ban had been in place for a long time, and we won't be in place forever, as I imagine other presidents will decide to move on from it. And then I want to just end by making one last statement about this case. There's another legal issue buried in this case that's of tremendous importance to states and that really got kind of glossed over because it really didn't matter, and that's the issue of nationwide injunctions. All you hear about these days are the courts issuing nationwide injunctions over the Clean Power Plan, over waters of the United States, over sanctuary cities. And the court didn't have to grapple with the nationwide injunction issue because, remember, Trump won, so there's no more injunction against him. But we had Justice Thomas writing a dissenting or a concurring opinion saying, I think these nationwide injunctions are just a piece of junk. And the truth is the Supreme Court has done very little to define the standards for nationwide injunctions. So it'd be very interesting to see going forward how the court reacts to this issue. Some of the litigation over sanctuary cities, may be likely to resolve this sooner rather than later. So partisan gerrymandering, oh man. I was waiting for Justice Kennedy in his final moments to sort of blow up the universe and come up with a standard for partisan gerrymandering, and it just wasn't sort of meant to be. So for those of you who don't think about and dream about partisan gerrymandering every day and night, I'll give you a little bit of a brief history on it. So in the 80s, the Supreme Court had said, we do believe that some amount of partisan gerrymandering is just too much. Some amount is unconstitutional, but we can't say when. Most recently, it was Justice Kennedy in 2004 who said, you've given me a bunch of tests for when there might be too much partisan gerrymandering. I don't like any of them. Come back with your fancy mathematicians and we'll talk. But right now, I don't like what you've given me. So that was 2004. So fast forward to this last term, the Supreme Court had two opportunities to finally lay out a standard for unconstitutional partisan gerrymandering and declined to do it in both cases. But interestingly, neither case is over. The cases were very different. I'm only going to focus on the Wisconsin case because the Maryland case was really kicked out for very, very procedural reasons. The Wisconsin case involved a statewide equal protection vote dilution challenge to a state legislative redistricting plan. So many of you, I'm sure, are familiar with packing and cracking. This is the idea that you put all members of one party in one district or a few districts, and then spread them very thinly throughout other districts so that they're not sort of spread evenly throughout the state so that they can get more voter districts. That's the basic concept of packing and cracking. So the allegations made in Wisconsin was that there was tons of packing and cracking going on, and that the electorate is divided about 50-50 Democrat and Republican, but that Republican legislators were way overrepresenting in the state. And the test that the challengers pointed to is called the efficiency gap, and it measures wasted votes. It's kind of a complicated math formula, at least for those of us who think simple math is complicated. And basically, The lower court in Wisconsin said, we like the efficiency gap, and we like looking at some other factors, and we think there was an unconstitutional partisan gerrymander in this case. What the Supreme Court said was basically this. To bring a partisan gerrymandering case, you have to show that there was individual harm to you. To claim that other people or in other districts were somehow affected, or that there was some statewide harm to you, that doesn't show an individual harm. That's not the kind of standing that we're looking for in the Supreme Court. We want an individual harm that's unique to you. It's not enough for you to say that there aren't enough Democrats in the state and you're a Democrat. But like I said, the court said that the challengers could go back and try to show standing. Now, this is where the case gets really interesting. There's a 4-judge concurring, maybe dissenting opinion, I think it was concurring, written by Justice Kagan. And I call it the imagine opinion. So what Justice Kagan basically says is, okay, I agree in this case there wasn't standing. But imagine that a different case was brought and other arguments were made regarding standing. Imagine that the arguments were X, Y, and Z. Imagine that the claims were this. And she just kind of lays out what her ideal partisan gerrymandering case might look like. So a couple of things about all this. People that believed, including me, that Justice Kennedy was not going to retire had cited to this opinion. Because what you see in here, Rick Hessen describes it, is the fighting for the heart and mind of Justice Kennedy. You have Roberts and Kagan sort of trying to convince him, look, there's a way to figure all this out. I wasn't surprised to see that he didn't join this opinion. It's very speculative. It's very sort of theoretical. So what happened after this case was decided is there was a lengthy dialogue about is it harder or easier now to bring partisan gerrymandering claims? Some people said harder because the court has come up with a rigorous standard for standing. Some people said easier because at least they've come up with a standard for standing, sort of. Now the conversation has completely changed. The conversation now is basically, is partisan gerrymandering dead? Is there any chance in the near future the court will come up with a test for when too much partisan gerrymandering exists? The short answer to that question is yes, partisan gerrymandering is probably dead. If there are really 5 solid conservatives on the court, it's hard to imagine a scenario where someone comes up with a test for partisan gerrymandering that those conservatives like. But I offer you a couple of caveats. And the caveats are as follows. Some people have speculated that Kennedy wouldn't go all the way in this case because things weren't really that bad in Wisconsin. Well, let me tell you where they're really bad. Anyone here from North Carolina? Anyone see the recent article about the partisan gerrymandering today in the New York Times on Michigan? The court hasn't seen anything yet until they've seen the cases from North Carolina and from Michigan. And the Michigan case is not very well developed at all. The other thing is this. We've had lower court after lower court said, oh, Supreme Court, you can't come up with a standard? Too bad, we will. And you can just knock it down. And I think we're going to see more of that from lower courts. And then we have the Pennsylvania situation. So Pennsylvania state court said, we're going to come up with our own standard for partisan gerrymandering. Forget the federal constitution, we're going to do this on our own in Pennsylvania. So I think there are still some moving parts in partisan gerrymandering. I don't know that it's entirely dead, but it's definitely on life support, and I don't think Justice Kavanaugh is going to come in and save it, which, you know, is good for state legislative authority, and is interesting in this long sort of dialogue on partisan gerrymandering. So the sports betting case, this is the Murphy versus NCAA case. Before it became the sports betting case, it was the Christie case. I don't know, there's just something about Christie as like the challenger in this case that when it became Murphy, it just sort of lost its charm. But anyway, Murphy is the new governor of New Jersey, and I'm sure he's a great guy, but he doesn't have the pizzazz, I guess, of Chris Christie. At any rate, many of you are probably familiar with the Federal Professional and Amateur Sports Protection Act. In this case, the Supreme Court declared the act unconstitutional, saying it violated the 10th Amendment's anti-commandeering doctrine. It was a 6-3 decision. So this is what PASPA does. It basically disallows states to allow sports gambling. And what was happening in New Jersey was that the Atlantic City casinos were struggling, and the governor really wanted sports gambling. He thought to himself, if this law is unconstitutional, we can allow sports gambling in New Jersey. So anti-commandeering, even for lawyers, this is a very arcane doctrine, as even Justice Alito admits. But basically what anti-commandeering is, it's the idea that the federal government lacks the power to tell the states what to do. Now, in one of maybe the best quotes ever for federalism, you'll see it in bold on the screen, Justice Alito basically says, When Congress wrote PASPA and said states can't allow sports gambling, that was the same thing as federal officers coming into state legislatures and writing that statute. And the court said it just can't be that way. It can't be that the federal government can just tell states what to do. So this is a really big deal because the court has only twice ruled that federal statutes violate the anti-commandeering doctrine. And the other reason why this is kind of a big deal is that the court struck down the entire law, not just part of it. Most people had thought what the court was going to say is, this is mere preemption. This is just the federal government preempting state and local government. It's not a big deal. And the court said, nope, this isn't preemption, this is commandeering. And another interesting thing, this is a 6-3 decision, but it's really not. Those 3 dissenting justices, they only objected to the fact that the entire law was struck down. They didn't actually object to the court saying that this involved anti-commandeering. So a number of states have gone forward and have started offering sports betting, and I'm sure more will be in the works as the next legislative session gets going. But I do want to tell you this story because I like acting like I know a lot about sports gambling, even though I really don't. But I do want to tell you this because it's important to know this. Sports gambling is not a get-rich-quick scheme, and I'll explain why, or it hasn't been so far. So PASPA had an exception for Las Vegas. So they've had sports gambling or sports betting, since the dawn of time. And so here's the deal. This is what Nevada collects in total gambling revenue, $875 million. That's a lot of money, right? Now look at what they get in sports gambling revenue, $16.6 million. Now here's where I get into my fancy sports gambling. Okay, we all place a sports bet, right? That's called the handle, okay? And that's not taxed in Nevada. What's taxed is the hold. The hold is the winnings that the sports book makes. So the sports betting industry is a lot like the grocery industry. You make 5%. In Nevada, they make typically 5.11%, or last year they made that number. So in other words, that's the amount that's getting taxed, just the profits. So it's a very small amount of money. Now you can imagine that there might be a different way to organize a tax scheme. But if you're just going to tax the hold or the profits, you're not going to make much money at all. In fact, what they say in Nevada is that, sports gambling is just an amenity. So you're really there to see Celine Dion, or I would really be there to see Celine Dion. But if I might want to just place a sports bet, no problem. That's kind of how they see sports gambling. So I know a number of state legislatures are pretty excited about this, but I would be more excited about the South Dakota versus Wayfair decision. It's going to give you way more money. So there's been a lot of talk about possible impacts where the federal government is also telling states what to do in instances that are sort of similar to what was happening in this case. And interestingly, for those of you who follow the sanctuary cities discussion, there's this law called 1373, and it basically says that it prohibits state and local governments from restricting employees from sharing immigration information. So before this ruling, a number of courts had said, this law might be unconstitutional anti-commandeering, but we're not really sure. After this ruling, within days, a court had struck this statute down. It's now been struck down 3 times. So this case has bigger implications than just sports gambling. And this basically means, just as a practical matter, for those of you who are interested in the topic, that the Trump administration has effectively lost every single legal claim it has made regarding sanctuary jurisdictions, now including this, except maybe the nationwide injunction issue. So the next case I'm going to talk about is an interesting voter case that I tend to feel a little defensive about, and I'll tell you why as we go along. So this case actually got more media attention than I think it normally would have, and part of the reason was it came out in early June, and the court didn't really release any of its really big opinions, and so all the reporters were like waiting for something big, and I'm not trying to say this case isn't big, but it's not as big as a lot of the other cases, but like I said, it just got a lot of media attention. So Ohio has a process of basically doing this. To clean up its voter rolls, the first thing it does is it pulls the change of address database, and it takes everyone off who's done a change of address, right? After it does that, it looks to see who hasn't voted in 2 years. If you haven't voted in 2 years, you get a postcard, and the postcard says, do you still live at this address? And if you do, can you write us back and say that you want to stay on the voter roll? Everyone, ignores that, but they get it. Then, if you don't vote for 2 more election cycles or 4 years, you basically get removed from the rolls. So this is the process that Ohio used. And interestingly, this process is totally blessed in the National Voter Registration Act. But there is another clause in the Act that says you cannot be removed because of your failure to vote. So the argument made in this case is that people are really being removed because they're not voting. If they don't vote 6 times, essentially, they get thrown off. And Justice Alito said, no, 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 no. The language says, or other language says, that you have to be thrown off solely for a failure to vote. Here, you're thrown off because you didn't vote and you didn't respond to a postcard. So that's how the court ended up resolving this case. So like I said, this case is a big deal because it involves voting. It involves Ohio. It involves people getting tossed from the voter rolls. And 12 states use a process identical to Ohio's, and a whole bunch more states use a process that's very similar. And now, of course, all 50 states can use this process. So in the opinion, Justice Alito very much tries to make this case simply about reading the text of the statute. It said sole criteria is voting. You're not solely thrown off for voting, so you don't need to look any further. Justice Sotomayor, again, in a more emotional opinion, says, look, the NVRA was to protect people and keep them on the rolls, not to actually get rid of them. And I have some headlines here that, again, illustrate how this case is perceived as being political. But, NCSL filed an amicus, or the State and Local Legal Center filed an amicus brief in this case. NCSL joined the brief, as did, I think, all the organizations I work with except one. I consider this the most controversial case we've ever filed an amicus brief in for all the reasons I said about the last slide. But this is the reality. There has to be some process from removing people from the voter rolls, other than people doing change of address, because most people don't do that. And the reality is that the Department of Justice, over many years, had used this as a settlement, this process as a settlement agreement when local governments were sued because they had tons and tons of dead people on their rolls. So states had to come up with some way to get people off the rolls, and this really gives people, 3 chances to vote over 6 years before this happens. But it's still a case, like I said, I feel somewhat defensive about because I do see it as a good governance case. It's absolutely not at all perceived that way by the general public. And the truth is, only time will tell how states actually use it, if they use it as a way of weeding people off or for more nefarious reasons. So again, unreadable, I know, but if you give me your card, I'm happy to email you my presentation. These are the states that use the Ohio process and the states that use a process that's similar. So the Masterpiece Cake case, oh my, this was another one of those sort of Supreme Court duds. I have to tell you, I was just at a presentation, and there was a male speaker and a female speaker that almost came to what I thought was going to be physical blows over this case. And the moderator just kind of like let it go on. And I mean, I would have cut them off just as soon as I could. This case raises the temperature in just about every room. And the Supreme Court really just sort of took a pass on it. So the issue in the case, I'm sure many of you are familiar with it. It was the same-sex couple wanted to get a wedding cake. Colorado has a public accommodations laws. All 50 states do, but theirs protected people on the basis of sexual orientation. And not all states do, maybe, again, about 20. And so the cake maker said, look, I don't want to make you a cake. This violates my religious beliefs. And so the couple sued them. And in a 7-2 decision, the Supreme Court issued a decision that basically said nothing. What the Supreme Court said was that the Colorado Civil Rights Commission had expressed some animosity towards religion, and they really had. One commissioner had said, religion is used to defend all sorts of terrible things, like the Holocaust. And so, I mean, it was a pretty bad statement. And the court said, that's just not right. Now, my opinion what happened, like I said in this case, is that the court completely wimped out. Pardon me for using legal jargon, but there's a term called Latin term, de novo. It means of the new. When the Supreme Court gets a case, it reviews it of the new, as if no one had ever decided that case before. So all the Supreme Court needed to do was ignore the statements of the Colorado Civil Rights Commission. I mean, who cares what they said? They could just look at the statute and decide whether it's constitutional. But they didn't want to do that. The dissent, by the way, points this out. This is hilarious, and I'm going to try to just do it like really quickly for you because it's so funny. This is at the oral argument. So Justice Kennedy asked the attorney who's arguing for the Colorado Civil Rights Commission, did the commissioner that say this ever go back on his statement? And the lawyer said no. Did the entire commission agree to this? Well, no. And then Justice Kennedy asks, well, I mean, was there, do you as the lawyer disagree with this? And finally the lawyer was like, yeah, I disagree with this. Like, I wouldn't have recommended my client do this. Like, and so that was like, that just sort of illustrates, like, this is Justice Kennedy's view of the case, and he really just didn't like the religious animosity expressed. But like I said, the court ultimately decided nothing. It said the cake maker won because he was the victim of this religious discrimination. But the court didn't say going forward, should the cake maker have won had there not been any religious discrimination? Was there really a free speech violation here? Was there a free exercise of religion violation? The court just didn't say. So this is kind of interesting. A number of people have pointed out this language. This is from the majority opinion, but mind you, all 9 justices sign on to this. And basically the court said, look, it's the general rule that businesses have to be open to all comers. And that's just kind of what our society agrees on. So a number of people believe that that will be the enduring lesson of this decision, but the truth is, I think a right-leaning or a left-leaning judge could find any of a number of things in this opinion to rely on. And in fact, interestingly, the court sent back another case called Arlene's Flowers, where Arlene said she was also the victim of sort of religious discrimination. But the Arizona Court of Appeals, maybe a day or two after this decision came down and said, look, we respect your religious freedom rights, we respect your free speech rights, you're in commerce, serve this couple. And that was kind of the end of it. So this issue will be before the Supreme Court again at some point, but it wasn't really decided this case at all. So these are the states that have statutes that also protect on the basis of sexual orientation. So the Minnesota Voter Alliance case versus Mansky, this is the perfect illustration for why the state and local legal center exists to file amicus briefs. We knew we could not win this case. There was zero chance of getting 5 justices to agree with what Minnesota is doing, but we felt we could get the court to write a narrow opinion that wouldn't be bad for all states, and that's exactly what the court did. And a couple of the dissenters actually cited to some materials in our brief. So now I know you're wondering, what in the world could this case possibly be about? Well, Minnesota has a state statute that says in polling places, all political speech is banned in attire. So if you go to the polling place, you cannot be wearing political attire. So of course, Andrew Selleck, donned himself in his Tea Party attire, his Please ID Me badge. He probably had political pants on that the court didn't even talk about. So he shows up at the polling place in clear violation of the statute, just basically to sue, claiming that the statute is overbroad. The Supreme Court agreed and said the statute is overbroad. They said, there's a big problem with banning all political speech at the polling place. The court said, Minnesota didn't define what was political. They said it could be any issue an oral argument, any issue that might be discussed in the campaign. And the court's like, look, the people who work at polling places are in their 80s. You really expect them to have a list of all the topics that came up and make sure there's no one wearing a T-shirt that might cover one of those topics? And the court said the definition also included, like, groups that promote political views. And Justice Roberts was like, the Boy Scouts have political views. So a Boy Scout leader comes in with his uniform and he can't vote? Like, this doesn't even make any sense. And interestingly, this is very, very rare for the Supreme Court to do. What the court did was it said, okay, we didn't like this full-on ban of political speech, but we agree states can regulate campaign-related speech. And we're going to give you 2 examples of statutes. Now, we're not saying they're constitutional. We're not going to go that far. But we're going to say they're more lucid again. I mean, Justice Roberts should do the SAT like vocabulary section. These are lucid examples of regulating campaign speech. So again, like I said, the dissenting justices cited the SLC brief and talked about the fact that a lot of obnoxious things happen at polling places, and that there's good reasons to regulate speech, even if the majority of the court wouldn't go along with that. Okay, and here are the states that don't regulate apparel. So the rest of the states do regulate apparel. And for those of you in the audience, I've seen a couple of you who work for state legislative staff, you're going to have this problem in front of you at some point. And like I said, focus on the Supreme Court's examples that it described as lucid. So this case got a lot of attention. And sometimes when I haven't talked about it, it's the number one case that I get questions on, like after a presentation, where people wish I would have talked more about it. So this is the NIFLA case, NIFLA versus Becerra. And this is actually, I keep on calling it an abortion case, but it was actually the Price's pregnancy clinic case. The long and the short of it is California passed a law that basically said, not if you're a crisis pregnancy clinic, but if you're something sort of like that, that if you're unlicensed, you had to disclose that. And if you were licensed, you had to disclose that you didn't offer abortions. The backstory is that there's tons and tons of these clinics in California, and Justice Sotomayor got in a lot of trouble by talking at oral argument about how she went on the website of one of these places and saw a woman in a white outfit, conveying the idea that the woman was a nurse. I believe it was Justice Kennedy who was like, do not go out of the record, Justice Sotomayor, or I'm going to come and get you. But you know, you're not supposed to go off the record. But anyway, that was what was going on in California. Was the legislature was concerned about these crisis pregnancy clinics that may have presented themselves as being medical clinics, i.e., abortion clinics, but were not in fact abortion clinics. So I'm going to focus on what the court did with the license requirement, which is where if you're licensed, you just had to say we don't do abortions here. So the Ninth Circuit said, you know, this is professional speech. So we're not going to regulate it as strictly as we would regulate other speech. The Supreme Court said we've never recognized professional speech. So it applied strict scrutiny, and basically the court said there's tons of places that women could go if they were pregnant, including just the normal clinic that they go to. But that normal clinic that they go to doesn't have to say we don't do abortions. So the court said there's no way this is, you know, this is narrowly tailored. So that was kind of the bottom line holding. But there's a lot of other interesting things going on in this case. There are tons of requirements that state legislatures have passed that are notice and disclosure requirements. For example, you have to, you know, wash your hands. Like businesses have to post signs that say, wash your hands after using the bathroom if you're an employee. That's a notice requirement that state governments require. So does now strict scrutiny apply to that? That seems kind of crazy. And the dissent, this is what our amicus brief focused on, the dissent talked a lot about that in their opinion. But here's another interesting thing. Conversion therapy for minors, a number of states ban it. So conversion therapy is the idea that you can be converted from being gay to being straight. So like I said, a number of states say that's fine for adults, it's not fine for minors. And courts have upheld these state statutes using professional speech, which the court says we don't recognize as a category of speech. But on the flip side, there might be another consequence that comes out of this case that people might not be aware of, which is, you know, a number of state statutes, for example, Texas, Louisiana, require women to look at a picture of the fetus before having an abortion. That will also probably be struck down as a result of this decision, because again, it's content-based speech. Like, you have to be shown a specific picture. So this case could have a lot of consequences outside of not just the abortion speech context or the crisis pregnancy speech context, but other contexts as well. So it's a very, very interesting case. And I want to point all this out to you. This is Justice Kennedy's final words about the First Amendment on the Supreme Court. The California legislature included in its official history the congratulatory statement that the act was part of California's legacy of forward thinking, but it is not forward thinking to force individuals to be an instrument for fostering public adherence to an ideological point of view they find unacceptable. His point is simply that, look, these crisis pregnancy centers didn't want to talk about abortion, and they shouldn't have to. But those were his final words. He loved the First Amendment, as many Supreme Court justices do, and I'm not surprised that his final words were harsh words, to sort of put it in perspective. So I think the last case I'm going to talk about is the Carpenter case. This was that sort of famous cell site location data case. It was a 5-4 decision with Roberts joining the liberals and Kennedy being on the other side. So basically, I mean, this case is kind of funny because how the technology worked 10 years ago is not at all like the technology works today. This is how the technology works today. As I'm sitting here, not using my phone or looking at it, it's pinging cell phone towers all the time. And I don't have access to that information. I wouldn't have known my cell phone company had it except for the Supreme Court opinion, but Justice Kennedy seems to think all Americans knew that. But anyway, so that's what's happening. So it's a great tool to find out if people have are in a particular location when a crime was committed. So, of course, in this case, the robber was interestingly breaking into cell phone company stores, which is sort of funny. And the court got the police got a court order rather than a warrant, and got all his cell phone data, and we're able to pin him to 4 robberies. And so basically, there's this doctrine called the third-party doctrine. It's a long-standing Fourth Amendment doctrine. It's the idea that if a third party has your information, you have no Fourth Amendment rights to it. It's not even your information. And the court had applied this to like bank records and applied it to like a pen register, which dialed telephone numbers. And the Chief Justice was sort of like, give me a break. This is nothing like bank records or a pen register. Who even knows what this is? He's like, there are more cell phones in America than there are people. You know, we're all carrying one of these. And the idea that the government could find like endless information about your location is just not all right. So the court went on to say a warrant was needed. And I heard someone say, if you say something 3 times, you can say it's your own. But this is the first time I'm going to say it, so I can't pretend it's my own. But I think it's very interesting. This is from a professor, Alexandra Natputh. So I heard her talk, and I went back and basically made notes of what she said. What she said is, in the Warren Court years, when we had criminal procedure, basically, it protected everyone, but it was designed to protect poor people and minorities, right? And now, in 2018, the criminal procedure is being used essentially to protect everyone. But when I say everyone, I don't really mean everyone. I mean people who are resourced and have cell phones and have all the latest technology and all the new things. And so her point is that isn't it sort of ironic that we've really sort of changed how we look at criminal procedure from helping a certain class of people to helping more the affluent or at least the average. And so I think that's a fair point about the case. So now I'm going to wrap up in the last couple of minutes and talk about Justice Kennedy and Judge Kavanaugh. So here are my Justice Kennedy-focused observations for the term. This term, Justice Kennedy ruled the world. He was in the majority in all of big cases. South Dakota versus Wayfair, it was his idea, his opinion. The Kate case, he wrote the opinion. His theory of the case triumphed. In partisan gerrymandering, Roberts and Kagan were fighting for his heart and his mind. Why was he so indecisive this term? Why couldn't he make a decision on partisan gerrymandering or the Kate case? Maybe because he knew he was leaving, and he knew the future wasn't really with him. And the issues that came up in the Kate case, they're going to come up over and over again. Same thing with gerrymandering. It's a huge issue. Why was he so conservative this term? I would venture to say because he is a conservative, but just not a reliable one. The other thing, too, and this is maybe my most important point of this presentation for all of you, he was really angry this term about misbehavior on behalf of government. In fact, I would go so far as to say he was enraged about it. In the Kate case, that case entirely revolved around one commissioner's discriminatory statements. I read you what he said in the NIFLA case. I mean, he couldn't have been more angry at the California legislature. There was another retaliatory arrest claim where he was very angry at the city council for plotting against the citizen. And in the travel ban, oh boy, did he have something to say. I'm not going to read this, but I'm going to just sort of summarize it. And this is what I'm going to say about it. These are his very, very last words that he issued in any Supreme Court decision when he left the term. They are in the travel ban. They are a concurring opinion. Now, these words may seem like they were geared towards President Trump. They were geared towards President Trump. But they're also put in context of all elected officials. What he basically says is this. Look, we didn't review very closely the statements that President Trump made. But that doesn't mean that a president or any other elected official can go around acting or speaking in a discriminatory manner. In fact, he says, it's the fact that you took an oath of office and the fact that I, as a Supreme Court justice, can't review those statements that make it all the more serious that you take that seriously, that you not violate your oath, that you not be discriminatory, and that you not say all these things. And then in his last sentence, he says, an anxious world must know that our government remains committed always to the liberties the Constitution seeks to preserve and protect, and that freedom extends on outward and lasts. I mean, those are words to live by if you're an elected official. And those were his final thoughts. I mean, that's what he wanted to leave you with and all Americans with, and quite frankly, President Trump with. So what does this term say about the court, our democracy, and the role of Justice Kennedy? I would suggest a lot. The Supreme Court is incredibly powerful. They decide, they pick and choose what they decide, when they decide, and how they decide. They never stop, and they rarely slow down. And they decide many important issues of the day. And they have the final say, of course, on constitutional matters. Should it be this way? Should it be that only 9 unelected people who are appointed for life, who are relatively homogenous, not average, and never young, make all these very important decisions? Well, that's something I guess our society has to decide. But for better or for worse, these qualities make the Supreme Court nimble, decisive, and skewed. If it had to be that way, in my humble opinion, we were lucky to have Justice Kennedy right where he was. Everyone in this room, every single person in this room, agrees with many of his decisions. And in South Dakota versus Wayfair, we see his humility and his curiosity. And I think whether we like it or not, the Supreme Court has become our collective voice and our collective conscience. And Justice Kennedy made that a moderate, thoughtful, cautious, and open-minded voice and conscience. And now he is leaving. So where did he provide the critical fifth vote? Anything and everything. I mean, if you name it, he provided that fifth vote. Where was he liberal? LGBTQ issues, most notably the death penalty. Race sometimes, abortion sometimes, rarely, but sometimes, and particularly later on in his career. So who is Judge Kavanaugh? You know, the truth is we don't really know that much about him. Even though we have all gobs and gobs of information about him, we don't know that much about him from a state and local government perspective, to be more specific. What we do know is this: he's very conservative. He could be more conservative, but he is very conservative. He's been put somewhere between Thomas and Gorsuch and Alito. Over a third of his opinions are on administrative law. This has everything to do with the fact that he's on the D.C. Circuit. And this is why I feel we don't know that much about him in terms of state and local government, because he's on the D.C. Circuit, which very rarely issues opinions in bread and butter issues affecting local government. The only local or state government that the D.C. Circuit deals with is D.C. So we just don't have very many rulings. But the conservative is like the tail wagging the dog. Because we know he's a reliable conservative, we can make all sorts of assumptions about him, for better or for worse. So from what we've seen so far, he's pro-employer, pro-law enforcement, pro-gun, pro-free speech, but I only say that because all Supreme Court justices are pro-free speech. He's anti-agency deference, and he's anti-environmental regulation, which may have more to do with him being anti-agency deference than anti-environmental regulation, but those are so deeply entwined that it's sort of hard to say. We can guess he'll be pro-property rights. All conservatives are, most at least. I guess he'll be pro-religion in public spaces. Again, not many opinions in that space. My guess is he'll be pro-closing the courthouse door, and that he'll be anti-race-based decision-making. On that note, though, I find it interesting that Judge Kavanaugh cites one of his most important opinions as where he said that using the N-word one time can create a hostile work environment. I don't doubt that that's one of his 10 most important positions, but I do think he talks about that case, just like he talked about all his interactions with women, for a reason. So will he get through? I guess that's sort of a million-dollar question these days. And I will tell you, like in the DC circles, so I'll tell you like one of my little secrets. Part of what I do to get ready for this presentation is I hear what other people have to say. And in the DC presentations that I've seen, no one even talks about Judge Kavanaugh as if he won't get through. The assumption is made that he will simply get through. And the reason is because, of course, he only needs 51 votes. You may find it interesting. I haven't checked on this in the last couple of days, but he was polling. My husband actually pointed this out to me. He was polling at the numbers of Bork and Harriet Miers just a couple of days ago, meaning he shouldn't get through. But why is he going to get through? Before you needed 60 votes in Congress, now you need 51. Doesn't matter what you and I think of Kavanaugh. It simply matters what these 51, if there's 51 Republicans, essentially will get him through. So the Republicans have exactly that number. Even if McCain doesn't vote, they have Pence. But I will caution you and say one thing. There is no issue like abortion for people to get crazy and irrational or to do things that they wouldn't ordinarily do. And so I do think that's a caution worth noting, but it's a small one. So there are a couple of Republicans who have indicated they may. Collins and Murkowski have been very, unclear about it. Rand Paul, I heard he was worried about privacy considerations. It turns out those are Fourth Amendment privacy and not abortion privacy, but anyway. And then there are 3 Democrats who voted for Gorsuch, and then there's McCaskill, who also is in a tough race, and Doug Jones is kind of in an odd position, like he shouldn't have won except he was running against Roy Moore, so he's kind of in an odd spot. But the long and the short is conventional wisdom says he gets through, and the word on the street is that if McConnell has said if the Democrats keep on elongating this process, he's going to push the vote out till right before the midterms, meaning we're unlikely to see Justice Kavanaugh on the bench right away, but we're likely to see him soon. So with that, I have 5 more minutes, and I'm happy to take some questions.
So I'm really intrigued, Lisa, about the partisan gerrymandering standing decision.
Right.
Because for those of us who are involved with redistricting, you can't look at an individual district in the abstract. There's a cascade effect that affects every district, and you may pack here and crack there and so on and so forth. Do you think that that they'll be able to challenge a single district, or that the strategy will be that different voters in a multiplicity of districts will file individual challenges and use that as a means to get the court to look at the entire plan?
It's a good question, and not one I really feel that comfortable saying that I know the answer to. I think only time will tell. I think we're just going to see a lot more experimenting with partisan gerrymandering going on. I suspect any and all theories are possible on the table as a result of the opinion, and that it's really hard to say.
Do you think Justice Roberts, given proposed nominees Kavanaugh, Chevron possible negativity, you think Justice Roberts will play the deciding role on that?
Okay, that's a great question. So there's been a lot of talk about the Supreme Court possibly overturning, if not Chevron deference, at least our deference. And these are deferences that in the administrative agency sphere where basically courts look to what an agency interpretation of a statute is. So a number of justices have been critical of Chevron deference. I am not even, I think it's been Alito, Gorsuch, and possibly the Chief, or maybe Thomas. I think at least one of the conservative justices has not publicly taken an anti-Chevron position, but interestingly, Judge Kavanaugh has indicated that he is anti-Chevron. So to answer your question more directly, I think Chevron is in trouble. I think very likely all the conservatives would be needed to overturn it. So who's ever sort of the holdout, be it Roberts or Thomas, is going to have to be sort of persuaded. And I'll just make one other point, which isn't exactly what you're asking, but it's just sort of another interesting thing. The Supreme Court has accepted 3 cases next term where they're contemplating overturning precedent in the question presented. So I don't know if the court's sort of ripe for this, but I do think there's a good possibility that Chevron goes, if not sooner than later.